Hey everyone, welcome back. Gabriella Huffman here to help you study for your North Carolina real estate exam. In this video series, we're going to focus on Chapter 9. From Chapter 9, I'm just going to focus on offers. So there's a few things we need to understand, some new words, some definitions. So statute of frauds versus the Connor Act. Statute of fraud says to put documents in writing to be legally enforceable by a court of law. Connor Act, on the other hand, says to record documents in the public record through the Register of Deeds, for example, to protect against third-party claims. Unilateral contract versus bilateral contract. These are the different time periods that you'll experience while under contract with a property. The unilateral, the uni part of the contract, really good example would be during the due diligence period. So once buyer and seller go under contract, and if there is a negotiated due diligence period, the buyer is the only one during this time period that can choose to move forward with this purchase or choose to get out of the purchase. So it's a unilateral, meaning one person has the right to make a move. While the seller is under contract, they really can't make a move at this point. So the buyer has this unilateral contract or time period of the contract while in the due diligence period. Once out of due diligence period, once that period has expired, we're said to be in a bilateral contract, by being two. So now both the buyer and seller are going to perform to get to a close. So the buyer is going to buy and the seller is going to sell. Express contracts versus implied. Express is what we need. Express can be oral or in writing. This is a definite, I'm working with you, you're working with me. Implied contracts are like assuming we work together, which are not legal in North Carolina. So you want to have express agreements with your clients, whether that's oral or in writing. Okay, addendum versus amendment versus counteroffer. An addendum, notice the first three words show you add. So we are adding a document to the sales contract. The sales contract has standard language, so there may be a particular type of sale. Let's say your buyer is an FHA or VA buyer. So an FHA or VA addendum would be appropriate to add or attach to the sales contract to address some more terms that would be in a typical FHA or VA transaction. An amendment, to mend, to bring together, to fix, I think to sew, is to change something in the sales contract. So it can be any change, whether it's the sales price, the earnest money amount, the due diligence fee amount, the settlement date, the due diligence period, any change from the original signed contract is called an amendment. And remember that any amendments that occur, all parties must initial and date beside those changes to be valid. A counteroffer is a counter to an offer or rejecting that original offer. So notice an amendment is a change to an already existing signed contract, versus a counteroffer is we are countering or changing that initial offer. I love this page on 256 in your book, Legal Effects of Contracts. Chapter 9 talks about void and voidable. Those are the two you really want to focus on. Void is very simple, no legal effect. So a really good example of this that we use in Chapter 5 is someone who is legally incompetent. They're not of sound mind. They're not able to make decisions on their own. So contracts with those individuals are automatically going to be void. Voidable, on the other hand, is valid. It's still a valid contract, but can be disaffirmed, rescinded by one party, and that is the party that is under the influence. For example, voidable would be someone who's intoxicated or drugged. So I could go out to drinks with a client, we sign a legal document, they can wake up tomorrow and say, I'm not quite comfortable with what I signed yesterday. I was under the influence. So that one party, the one who is under the influence, can disaffirm or rescind what they had signed. Now, it's not automatic. There is a statutory period in which this happens, which we let the courts decide on. So voidable is still valid. They can wake up tomorrow and say, yes, that was a fun night. Let's go to closing. Let's do this, and still be fine. Or they can wake up the next day and say, you know what, wasn't quite comfortable with the decisions I made at that time because I was not at the right state of mind in that temporary time period. So know the difference between void and voidable. 4 elements of a valid contract. This is always on your test. And the Real Estate Commission gave us an acronym, CLAP, C-L-A-P. Your contracts need to state consideration, something of legal value. It's got to be legal. Acceptance, that contract needs to be voluntarily accepted by all parties. And P, parties, all parties need to sign. Remember, if the sellers are married, 1 to buy, 2 to sell. So all parties have to sign. And please, please, please write down that earnest money is not required for a valid contract. There is no E in CLAP. Yes, earnest money is a part of the contract. It's not required though. You don't have to put earnest money down to have a legally binding contract. If there is earnest money, that earnest money can be used as liquidated damages to compensate the seller should the buyer breach or back out during the due diligence period. Formation of a contract. This is what I use in class. 2 things have to occur to actually create a contract. 1, we have to have acceptance of all party, and 2, communication. And this is big. Acceptance, communication. You have to have these 2 things to have a contract. So this is my favorite part of chapter 9, is going through a scenario on was a contract formed. And in class with the whiteboard, I draw stick figures, but luckily with the computer, I was able to find some images. So I always set myself up for success with this T here. I've got the buyers on one side, I've got the sellers on the other side. Notice my blue line. That's my line of communication. This is a very important line to pay attention to. So let's go ahead and bring in our clients. Barb, buyer, and Barry, buyer's agent. Larry, listing agent, and Susie, seller. So Barb, buyer, writes an offer, signs it. This is super important. When an offer is written and delivered, it is signed already by the buyer. Barb gets her offer to Barry, her agent, and Barry sends it to Larry, the listing agent. Notice we've already crossed that line of communication once. You have to cross that line of communication twice in order for you to have a contract. So keep that in mind. So the offer is now with Larry, listing agent. Larry, listing agent, gives it to Susie, seller. Susie has accepted it. What does that mean? She has signed it. So at this point, we have buyer signatures and seller signatures, but we're not there yet because remember, 2 things have to occur: acceptance and communication. So we're waiting for that last thing to happen. So Susie, seller, gives it back to Larry, listing agent. So the question is, do we have a contract? Well, the answer is no, because it did not communicate back to the buyer side. The buyer side has no idea that Susie, seller, has signed. So remember, the communication needs to go back to the offeror. It needs to cross this blue line of communication twice in order to have a contract. So unfortunately, when it left at Larry, we're not there yet. Larry needs to call the buyer's agent, email, fax, text, whatever to the other side to communicate that acceptance. And remember, communication to the agent is the same as communication to Barb. So if Larry were to call Barry, hey, we've signed your offer, we're under contract. We don't have to wait for Barry to call Barb. Communication to the agent is the same as communication to the client. So methods of communication. Well, I want to point your attention to the little figures here. You have the offeror, who is the one who created the offer and gives it to the offeree. That's the one receiving the offer. So in order to have a contract, the offeree needs to bounce it back to the offeror. So keep that in mind. That's a really good question for the test. When do we have a contract? When it goes from offeror to offeree back to offeror. So there's different ways that we can have valid methods of communication. We can email, fax, text. These are great because they're all time stamped. We can call. I know you have a hard time with this. Well, it's not in writing. It's still communication. But you've got to pay attention to the question. If the question says, or one of the answer choices says, listing agent calls the buyer's agent and says the seller intends to sign, that doesn't mean anything. That's not a contract. Intending to do something doesn't mean it has happened. But if the listing agent calls the buyer's agent and says the seller has signed, we have communicated acceptance. We are under contract. Another way to communicate is through the mailbox rule. There's a lot going on with this rule, but we're going to keep it simple for pre-licensing. To accept an offer through the snail mail postal service, an offer is considered accepted once put in the mail back to the offeror. Now, don't worry about, what ifs, what abouts, leave that for the courts to figure out. But on the test, no, to accept an offer, once it has been put back in the mail from the offeree back to the offeror, to be mailed to the offeror, that is considered accepted. So how do sellers respond to offers? I get this question all the time. Well, they can accept them. They can reject them, which, remember, kills the original offer. You cannot resurrect that original offer if you've rejected it. You can counter. And remember, you can counter on anything. It doesn't have to be always the sales price. It can be earnest money, due diligence fee, settlement date, whether you want a home warranty or not. Anything in there can be countered, which again kills that original offer. You cannot resurrect it. It's gone. Or the sellers don't have to respond. Is there a time limit in which sellers must respond? There's not. So keep that in mind. I get this question all the time. When are we supposed to hear back from the sellers? When do the sellers have to respond? They don't. There is a form, there is an addendum, remember, an added form to the sales contract in which you can put a stipulation of time. But if that addendum is not used, then the seller can respond whenever they want to. Multiple offers. This is very important for the test. The fact that the seller has multiple offers is not a material fact. It is not a material fact. So I, as the listing agent, do not have to tell buyers or buyer's agents, hey, we've got offers. It's personal, confidential information to the seller. Keep in mind, even if there are no offers on the table, I still can't say anything. So before you say or respond to that question, are there offers, you need the seller's consent to say that. If they did not give you consent, then you cannot disclose. This is their confidential information. Disclosing terms of an offer, not material. So when this happens, you're going to be a listing agent and you're going to get two offers on the table. And your seller is going to say, listing agent, I want you to tell offer A what offer B offered. I want to get a bidding war going on. Sorry, seller, I can't do that. It's not my offer. It's not your offer, seller. It's the offeror's, or typically who starts the conversation, it's the buyer's offer. So if I'm going to show the buyer's offer or their cards to somebody else, I need their consent to do so. Otherwise, I cannot disclose terms of offers to anyone. So what are terms? Any fill in the blanks of that 2T form or the offer form being used. That's sales price, type of loan, closing costs, you name it. You have to have whoever created that offer, their consent to disclose. Well, that's it about offers. If you have any additional questions or comments, you're welcome to reach out to me. Otherwise, I'll see you in chapter 10.